So I think city C1 or C2.
Sure, that makes sense. Or we can go the next in order, however
Yeah.
they would prefer it.
I usually check off who's here. I didn't.
Yeah, no, it's been
That makes sense.
no with somebody.
That makes sense.
Randy. I'll talk to you after.
Are we on, Keith? Yes, thank you.
Right.
Thank you.
So, good evening, ladies and gentlemen. I'd like to welcome you to the special meeting for the public hearing on Issaquah Highlands retail and medical office and self-storage, and we'll start.
Sorry, I'm still opening a file.
Want to hold up till she catches up.
Most.
Is that single file? No.
Okay.
How many? You keep your day job.
Okay, ready, thanks.
All right, great. I'd like to welcome you all to the special meeting of the Development Commission, reviewing the public hearing and holding a public hearing and talking about the Issaquah Highlands retail, the medical office, and the self-storage administrative site. And I'll turn the time over to Mr. Zell.
Thank you, Mr. Chairman, members of the Commission. My presentation tonight will consist of a redirect examination of Mr. Niven and then a direct examination of Lucy Sloman, the city's land development manager. I do have a couple of preliminary points, if I may.
Yes.
First of all, the city will be submitting and introducing several exhibits this evening, and for purposes of identifying those, be happy to mark them as a C for city, a 1, 2, 3, 4, if that works for you, with the understanding that the city's first exhibit was the staff report and attachments that were submitted at the commencement of the September 26th proceeding.
Okay.
Second, just for the Commission's edification, the last time we met, there was a pending appeal, I believe, of the staff report that the city had prepared for this proceeding. This is just to inform the Commission that that appeal has been dismissed. As of this Tuesday, the 27th, the city's hearing examiner issued an order dismissing that appeal.
Okay.
Okay. And with that, I would be happy to proceed.
Please do.
Thank you.
Hey,
Calm.
I'm having a lot of trouble hearing with that fan. Is there a way to turn that?
No. It's the projector for the screen.
Okay,
Does that work better?
that's better. So everybody will have to be aware of that, and I'll just interject if I can't hear you. Thanks.
Please start.
Thank you, Mr. Chairman. Mr. Niven, for the record, could you please acknowledge that you will continue to be under oath as taken from your original testimony?
I will.
Thank you. The first point I'd like to discuss with you concerns the allegations that the city had told IHIFC that it was vested. Do you remember that line of questioning during your cross-examination by Mr. Schneider on October 24th?
I do.
Thank you. First document I would like to introduce is City Exhibit C2.
Mr. Chairman, with your permission, I'm just going to hand these out.
Please do. Thank you.
And this is a October 2nd, October 3rd, 2017 email exchange between yourself and Tia Heim of Shelter Holding, or IHIFC. Do you recognize it as such?
I do.
Could you please describe or explain your response to Ms. Heim on October 3rd in this email regarding the determination made by the city for vested projects under the moratorium?
Sure. So when the city decided to enact a temporary moratorium on development last year, There was a conversation that needed to happen about what projects would be vested and allowed to move forward during the moratorium and which ones would not. And so what this email is back to Ms. Heim is identifying what decision the council made as it related to the moratorium and what would be considered vested permits.
Okay. And just to clarify, if I understand your testimony, Mr. Niven, your response to Ms. Heim in this email on October 3rd was specific to vesting as described or defined under the moratorium framework.
Yes, it was.
And did that include or exclude vesting as you understood it under the 1996 development agreement?
It did not include the development agreement because the development agreement, as were the other development agreements that are in the city, have different rules.
Thank you.
They were all considered vested.
Thank you. The next document I'd like to introduce and label as City Exhibit C3 is on November 21st, 2017 and November 22nd, 2017, email exchange between yourself and Tia Heim.
Yes,
You recognize it as such?
I do.
Okay. Could you please read for the record Ms. Heim's November 21st, 2017 message to you beginning with "Thanks, Keith"?
Sure. Thanks, Keith. We have not received any requests for additional information. I'm assuming that you mean that the applications are complete and vested to the development agreement as stated in the email below, as we discussed in our meeting with you today. Please confirm.
Thank you. And what was your response to her on November 22nd, 2017 at the top of this email chain?
Yes.
And what did you mean by that?
So the question that she asked that I was responding to was, I'm assuming that you mean that the applications are complete and vested to the development agreement. And my answer was yes, to the development agreement.
Did you mean by that response, that affirmative response, yes, that the applications in question would be permanently bound by the development agreement?
No.
Could you explain why not?
Because we all understood that the development agreement was coming to an end, since in September of 2017, the master developer had asked to terminate the development agreement, and we, by this time, had been under a process of working towards replacement regulations to take the place of the development agreement.
Mr. Niven, I believe that you just said that we all understood that to be the case. Is that your testimony?
I believe that's what I said,
Okay.
yes, sir.
And why would you think or conclude that we, I'm assuming that you mean the applicant as well, would believe or understand that?
Because that process was not, there was a lot of transparency to that process. It was a very public process. When we initiated working on the replacement regulations, we had discussed that with Shelter Holdings as a major property owner, or IHIFC, sorry, as a major property owner in Issaquah Highlands, as we did with the other property owners that had yet to be developed properties.
Did you have discussions, oral discussions to that effect with IHIFC's representatives?
Absolutely.
Thank you. I'd next like to introduce City Exhibit C-4, also a November 22nd, 2017 email exchange.
You do this very well. Oh, hey, this one's already labeled C4. Thanks, Jeff.
I'm doing better. I'm labeling it forward now.
Thank you.
Thank you.
Mr. Niven, I draw your attention, please, to Ms. Sloman's email to you at 9:29 a.m. on November 22nd, 2017. Could you please read that?
Her email to me, subject vesting, they aren't vested unless the council agrees to the vesting language, period. I'm confused.
What vesting language was she referring to?
She was referring to the draft language that was part of the replacement regulations.
Could you please read aloud your response back to Ms. Sloman at 10:03 a.m. on November 22nd?
Yes, my response to Lucy was they are vested at this moment under the DA, which would stand for Development Agreement. If the council removes the proposed vesting language, they will lose their vested status.
Thank you. Mr. Niven, the general time that these emails were being circulated or issued, was the city in the process of developing or promulgating the replacement regulations that are now codified at Chapter 1819B IMC?
Yes.
Thank you. I'd like to introduce City Exhibit C-5. This is an interested party email dated November 17th, 2017, and carried forward from another interested party email dated November 14th, 2017. Do you recognize it as such?
Thank you.
Yes.
Thank you. Could you please turn to the memorandum included with this email dated November 17th, 2017?
Okay.
And specifically, page 7 of that memorandum, Roman numeral 4, headed vesting.
Okay.
Okay. Was this email with the attached memorandum sent to interested landowners and project applicants within the Issaquah Highlands area?
Yes.
Did the email recipients include Tia Heim and Gary Young of the applicant?
And Eric Evans. They were all three.
Thank you. I'd like to introduce exhibit number City C6, please. For the record, this is a 16 November 2017 memorandum entitled regarding end of DA's dash application vesting and labeled attachment 4. Do you recognize it as such?
I do.
Is this the attachment 4 that was referred to in the other memoranda that I just discussed with you?
In Exhibit C5.
Okay. Could you please describe the purpose of this 16 November 2017 memorandum?
Yes, so this was an attachment to the Land and Shore Committee of the City Council, intended to help them have a conversation about vesting as it relates to the adoption of the replacement regulations, which ultimately took the place of the development agreement.
Did the city staff make a recommendation to the city council in this memorandum regarding what the vesting provision of the replacement regulations should provide? Refer your attention to the first paragraph.
Yes,
Okay.
thank you.
And could you summarize staff's recommended vesting approach for purposes of the replacement regulations?
So staff's suggested vesting approach, which got adopted with the replacement regulations, is consistent with state statute on vesting.
Okay. And in your original memorandum here, did you recommend to the staff recommend to the city council that it simply adopt state law vesting requirements, or did it recommend a more generous, broader vesting approach?
So it's been a while since I've reviewed this memorandum, so my apologies. I'm going to quickly, since you're asking me a number of questions, I'm going to quickly look through it, so I'm not shooting quite in the dark.
And I haven't been objecting to this question.
I'm sorry.
Please speak up.
I haven't been objecting to the leading questions, but this is an example of why it's inappropriate. The witness couldn't even answer a leading question. He's not familiar with the document. So I would ask that the witness be asked, what does it say, not asked whether it says what counsel thinks it says.
That's a good point. Please revise your question.
Thank you. Mr. Niven, could you please state what the recommendation in the memo says?
So the recommendation from the memo says the following rules shall apply to vesting of development applications for properties located within the urban villages previously covered by terminated development agreements. Do you want me to read it all?
No, I'm just asking you to summarize it, if you could.
So complete application shall be vested against the provisions of the chapter. So this construct on vesting, which displays the administration's original recommendation, was consistent with what the council enacted with the development moratorium.
Okay.
And so because that was a recent council action, staff took that as a cue that that's what the city council would support as it relates to the replacement regulations. So that's where we started our conversation with the city council.
Thank you. And again, this was a policy recommendation by the city staff?
Yes.
Thank you. Could you please state or describe the alternatives for vesting that are listed as 1, 2, and 3 near the bottom of the first page of this memorandum?
Absolutely. So alternative number 1 was do not include any language in the replacement regulations. Alternative 2 was allow all land use applications to vest subject to IMC, which is Issaquah Municipal Code 1804220D expiration, that have submitted complete applications for land use permit. Or 3, allow for vested rights to be limited to those applications specifically identified in state vested rights doctrine.
Thank you. And just for clarification, this November 16th, 2017 memorandum and the email that distributed that to the interested parties occurred within a week before your November 22nd email exchange with Ms. Heim?
Yes.
Thank you. I'd like to introduce City Exhibit C7. This is a December 14th, 2017 interested party email specifically addressed to Tia, Ken, Susan, and Sarah. Do you recognize it as such?
I do.
I believe we've identified who Tia and Ken are. Could you please indicate who Susan and Sarah as recipients are?
Sure. So Tia Heim, Shelter Holdings, or IHIFC. Ken Bellamy is part of TriMet Development. They own the commercial space in Tallis. Susan Wilson is part of Aura Tallis 90. They own the property that slid in Tallis, which currently sits undeveloped. And Sarah Hoy is the executive director of Issaquah Highlands Community Association. They were also own a piece of property and were looking to build an office space. So this went out to those parties that had potential vesting interest at stake as the city talked about vesting and the replacement regulations.
Thank you. Could you please turn to the 12 December 2017 memorandum that was included with that email? I believe it's the second page.
Yes.
Okay. Could you please describe the purpose of this and content of this memorandum as it relates to vesting?
As it relates to vesting.
Please.
So as we were approaching the end of the year, there were a couple big items related to the adoption of the replacement regulations that hadn't quite settled down yet. And those were vesting and the proposed floor area ratio requirement that were in the draft replacement regulations. And so what this memo was an attempt to provide that information to the city council as they contemplated ultimately what to do with the replacement regulations. And because of these two items and still a lot of conversation that wanted to happen, they actually continued it. They asked us to go out to the community one more time. And ultimately, we didn't adopt the replacement regulations until March of 18. But we had originally had hoped to have gotten them adopted by the end of 2017.
Thank you. Could you please turn to the third page of that packet? This is a table listing all pending permits. Could you describe how this was created and what its purpose was?
I'm chuckling because this is a Lucy table, and so Lucy's brain and my brain really don't work the same. What I believe this is intended to do is to identify those parcels that were not built out in both Issaquah Highlands and Tallis, and to identify based on where those parcels were in the permitting process, whether they were vested or not under the different alternatives that we presented in the memo.
Thank you. And with respect to the shaded references in the table to IHI or IHs or shelters projects, could you please explain what is meant by the shading on proposed vesting language in relation to those projects?
So I'm gonna say what I believe. I'm going to also defer to, I would assume you might ask this question of Ms. Sloman as well.
I'd be happy to withdraw the question and ask that of Ms. Sloman. That's
I think
fine.
I would be more comfortable with her answering that since this is her table.
Thank you. Be happy to do that. Shifting gears then, I would like to discuss briefly Appellant's Exhibit Number 1 that Mr. Schneider introduced into evidence at the October 24th proceeding. This is a notice of application that was issued for IHIFC's preliminary plat. Do you have a copy of that?
Yes, I actually have a copy of it.
Great. Do you recognize it as such?
I believe this is the document that Mr. Schneider handed out last time.
Do you remember Mr. Schneider's questioning of you on that point?
Could I just make a procedural suggestion? Now that the city is offering exhibits and calling them CE 1, 2, 3, I would suggest that our exhibits be marked S 1, 2, 3, and I think we have 7 exhibits admitted last time, so I would ask that those now be referred to as S 1, 2, 3, and we use that going forward as well, just for more clarity.
No objection. That makes perfect sense.
Yep, makes good sense.
Do you remember Mr. Schneider's line of questioning on that point, Mr. Niven?
Generally, it was the notice of application for the preliminary plat. think the answer was yes. There is a map on the back. The question, I think, from the applicant's lawyer was, does that show buildings? And I believe I said yes.
Thank you. Did IHIFC's preliminary plat application, when it was submitted in August of 2017, depict building footprints?
No, actually, if you look at the date on the map from KPFF, you can see that it was prepared December 14th, 2017. So this amended document with the building footprints came in December.
Thank you. Do you have any idea as to why the notice of application would show building footprints when the original plat application did not?
Well, the notice of application is typically put together by staff. My guess is they just grabbed a graphic that showed where this property was, and the building footprints were irrelevant to its purpose as part of a notice of application.
Thank you. I'd like to turn your attention now to a line of questioning during your cross-examination on October 24th concerning the procedure used for this hearing and how you came to decide that this Development Commission procedure was the appropriate one to use for this purpose. Do you remember Mr. Schneider's cross-examination and your responses on that topic?
I do.
Okay, thank you. I'd like to specifically call your attention to Exhibit 2, or what would now be S2, the declaration that you had previously submitted in the original hearing examiner administrative appeal by IHIFC. Do you recall that document?
Vaguely. I believe the line of questioning was about when we thought the permits were going to be decided. Is that the one?
Yes, and I'll quote to you from the transcript if I could. And this is, again, a quote from your declaration. Although not certain, I anticipate that a final decision on IHIFC's SDP and ASDP applications will be issued in June or July 2018, and that a decision on IHIFC's preliminary plat will be issued in August or September of 18. Do you recall that?
I do.
Okay. When you made that statement in your declaration, did you believe it was accurate?
I did. I'm always optimistic about how long it takes to review permits. The people that go through the process may not be as optimistic as I am. But at the time, I believe those were reasonable timelines to offer in terms of a reasonable expectation for decision on these permits.
Okay. Were you involved in the drafting and promulgation of the replacement regulations? Did your involvement include what is now codified at IMC 1819B 270, the procedural provisions of the replacement regulations?
Yes.
Okay. Were you aware when you executed or signed that declaration, from which we just excerpted, that the Development Commission would be the hearing and decisional body for IHIFC's applications?
I did.
Did you change your mind at some point regarding that point?
I don't think so.
Okay. Could you explain why, if you originally thought the final decisions on IHIFC's SDP and ASDP applications would be issued in, I believe it was the June or July timeframe, why it has taken as long as it has to process those materials and why we haven't reached a final decision yet?
So it's a complicated answer. What I would say is primarily the city faced some staffing challenges over the past year and a half. We had 4 permit plan reviewers leave the city employment, and we had to hire replacement staff. And the city was also working on a work plan to end a development moratorium. And the mayor at the time made it a priority of mine to make sure that the moratorium got ended as soon as possible. So not only did we have, I think, a significant amount of work in front of us, we also had a significant amount of staff turnover. But as it relates to why we are just finally now in front of the Development Commission, a lot of that had to do with the applicant and their approach to the permitting process. These permits have been basically waiting for revisions, which the applicant has chosen to not do. And eventually we got to the place where we felt like the only thing to do was to write staff reports for denial, which is why we are here now. They are still inconsistent with city code, in our opinion.
Was there any disconnect or confusion between yourself and any of the other staff members that may have been tasked with that effort that you're aware of?
Not that I'm aware of.
When was it brought, do you recall when it was brought to your attention that the staff reports, the documents that ultimately became the staff reports, would need to be forwarded to the Development Commission as staff recommendations? I'll rephrase that.
Yeah.
Did you have communications with Ms. Sloman at some point during the July 2018 period regarding the decisional body for IHIFC's STP and ASTP applications?
There, at some point, the two of us connected and had that conversation. I don't recall when that happened.
Could you briefly describe the substance of that conversation or those discussions?
Well, so taking a step backwards, when the replacement regulations were going through the council adoption process, there was a significant amount of conversation at the Land and Shore Committee of the City Council about the process, and having permits on major streets go through an administrative-only process was not in keeping with the council's vision of transparency. So the inclusion of basically sending permit applications to the Development Commission for projects on major streets, that was a very clear expectation of the City Council. So when it came time to review the process for these applications, I don't think there was any doubt in my mind that it had to go to Development Commission.
Was there possibly, euphemistically speaking, a left hand at City Hall possibly not communicating with the right on your staff about that point?
So as I mentioned, so Lucy and I did at some point make sure we were pointing in the same direction and giving the applicants the right information. I'm not sure that probably happened at the first step, but somewhere along the way we did connect and have that conversation.
Thank you. Did you intend to mislead or otherwise delay the applicant with respect to this procedural issue at all?
No, never.
Thank you. I'd next like to turn your attention to the issue of vested rights as they relate to IHIFC's preliminary plat application and Mr. Schneider's cross-examination of you on that point. Do you recall that line of inquiry and your responses?
I do. I think I asked why we were talking about the plat when there were other applications that were on the agenda.
A fair point, and I just want to set the record straight on that very briefly. One of the questions, I believe, during that colloquy or back and forth concerned the extent to which IHIFC was considered vested by virtue of its preliminary plat, and also why the city had allegedly refused or failed to make a determination on that point. Do you recall that discussion?
I do.
Okay. Could you please turn to attachment 10 of the staff report prepared for these proceedings?
What page number is that in the bottom right corner? Do you have that?
Page 4 and 5 of attachment 10.
What?
Oh, on the pagination that Ms. Sloman is referring to, it would be page 60. Beginning at the bottom of page 60.
Yes. Sorry.
No problem. Could you please read the two short paragraphs under section number 5?
5, yes. So 5 is entitled, "The extent of vesting afforded to IHIFC's plat is limited to use regulations and the specific development depicted in IHIFC's application materials. Under the state law standards adopted in IMC 1819C280, a complete subdivision application vests the underlying proposal, quote, only at a very general level, unquote, i.e. to the land uses allowed under the municipality's current regulations, quote, any specific project will still have to meet the development standards at the time the building permit is filed, unquote. Alliance Investment Group of Ellensburg, LLC versus City of Ellensburg, 189 WN. I'm going to not read all that. Where a plat application actually identifies a specific development plan or concept, such as building footprint, setbacks, etc., quote, what is vested is what is sought in the application for a ... plat, unquote, and that's Noble Manor. Based upon this legal framework, the city considers IHIFC's preliminary plat application to be vested to the use regulations set forth in the development agreement, comma, as well as any development standards in the agreement that are necessary to accommodate the specific development plan or concept, if any, identified in IHIFC's plat application materials.
Thank you. Do you construe your response that you just quoted as explaining to IHIFC the city's position regarding the vested status of its preliminary plat?
I do.
Thank you. My last series of questions, Mr. Niven, concerns the cross-examination testimony regarding how the city treated other applicants under the Issaquah Highlands Development Agreement, and specifically the Polygon applicant and its projects. Do you recall that testimony and that line of questioning?
I do.
Thank you. I'd like to introduce City Exhibit C8, please. Mr. Niven, can you please identify this document?
Yes, so this document is basically a document that was prepared to talk about this particular item, since at the last commission meeting, the applicant's attorney was asking me to basically attest to vesting language in a development agreement that was executed with Polygon, and I said I needed more time to really think about that. So this is the outcome of that more time. And so what this document is showing is, so IHIFC's property is blue, and Polygon owns the burgundy, orange, purple, and green, okay? And what you can see at the bottom is, so the burgundy property is a single-family plat, and that's called Single Family North. and they had a complete application in 7/24 of 17. And that application has moved on to preliminary plat approval, and they're beginning to want at least permits to do site work on the property. The orange is identified as multifamily south, or MF-S. It got its site development permit notice of decision 7/19 of 16, and it's well under construction, which then leaves us with the green and the purple. Both the green and the purple, one's identified as multifamily affordable housing, that's the green, and then the purple is multifamily north. But the reality is actually both of those projects have affordable housing components in them. And both of those are subject to a subsequent development agreement and affordable housing agreement that Polygon executed with the city. So the reason why those two parcels, green and purple, are being allowed to continue under the standards of the development agreement is not because they're getting preferential treatment by the city, but it's because there's a separate agreement to build out affordable housing in those two neighborhoods. And I included the section, so the recording number is listed, and then section 5, which is termination, which identifies when that agreement terminates.
Thank you. I have no more questions of Mr. Niven, and with the commission's permission, I'd like to call my next witness, please.
Do so, please do. Thank you, Mr. Niven.
Don't I get to cross-examine the witness on the new testimony?
The city's understanding was that each witness would be subject to direct examination, cross-examination, and then re-examination, and that wouldn't go on in a permanent cycle to that effect.
But anytime there's direct examination, I'm entitled to do cross. And new documents have been introduced. There's been testimony that contradicts the testimony last time. I think we have a fundamental problem if I'm not allowed to ask cross-examination questions.
I'll defer to your counsel on that.
We'll accept your proposal.
Thank you.
Mr. Chairman, if I could please, if Mr. Schneider does have an opportunity to further cross-examination, I would respectfully reserve my right to do more redirect to the extent necessary.
But, I just will remind people that we don't want to go on indefinitely, so we'll pay attention to that.
Thank you.
And we would like to be able to put up some exhibits on the screen. Could we have a 5-minute break to get the technology organized? I think it'll be more efficient and helpful if we do that.
Let's do so.
So if they're cross-examining me, why do they need exhibits? I also don't want to go on forever, and it seems like this is getting pulled apart a little bit. Just a question for the chair.
Well, Mr. Evans may not want to be cross-examined, but there's lots of material for cross-examination, and he doesn't get to decide whether he's asked questions or not. It's completely out of line for him to be making objections. He has an attorney here representing him.
We'll go through this one round. We'll cross-examine. We'll determine how laborious it is after we get a chance to see the exhibits.
Thank you. Keith?
Let's take a 5-minute break.
So it's going to go, somehow you have to establish some
So we're going to resume. I want to lay some ground rules. What our interest is at this point is, for this portion of the meeting, is we only want to address new information that came up during the redirect. And so that's the context of what we're going to be listening for. And if it looks like we're going astray of that, then I'll ask you to not do that, not bring that up. Is that agreeable?
Absolutely, Mr. Chairman.
Right.
Thank you.
Thank you.
So, Mr. Niven, you testified that, I'm talking about Exhibit C3, which was your email exchange with Ms. Heim on November 22nd, you testified that we all understood the development agreement would come to an end and that vested rights would end when the development agreement ended. Is that correct?
I don't think I said that. I think I said we all knew the development agreement was coming to an end, and we were enacting replacement regulations to take its place.
Well, isn't your testimony that when the development agreement ends, that the vested rights ended as well?
So that was a decision that the city council got to make with the replacement regulations.
Okay, and when did you decide that the city council had the authority to end vested rights?
So the city council got to choose whether they included language about vesting in the replacement regulations or not.
My question, Mr. Niven, was when did you decide that the council had the authority to terminate vested rights?
My decision, so I don't think I agree with your question.
Are you saying that you always believed that when the development agreement ended, vested rights would end at the same time?
No.
Okay, so when did you decide that when the development agreement ended, the council could terminate vested rights?
So there's difference between being vested to terms in a contract versus being vested to what's provided for in the vested rights doctrine under state statute.
And I'm not asking you to draw a distinction which I don't believe exists. I'm asking you when you decided that rights that vested to this development agreement could end by legislative action of the city council.
So my opinion is that the contract is a contract, and when the contract ends, the contract ends. And what is vested, if it's vested to something that is consistent with state statute, then it's vested. You can't take that by ending a contract. But if it's vested by rights of the contract, then it ends when the contract ends.
Mr. Niven, you have not yet answered the question that I have asked repeatedly.
So I've given you the answer I have. You're not going to get another one.
Mr. Niven, you don't
sir.
get to decide which questions you answer. I asked when you decided what you just testified to.
And I gave you an answer, and it was the best one I had.
So that's sufficient.
I'd like to offer an exhibit, please. It's
This would be, we leave off on 7.
Yes, this would be-
S8.
yes, S8.
And there's, who's taking the copy for the record?
I am.
While that's being handed out, Mr. Niven, who again is Sarah Hoey?
She's the executive director of the IHCA, the Issaquah Highlands Community Association.
Okay, and was she also interested in obtaining vested rights under the development agreement?
She was. They had hoped to build an office building.
You recognize Exhibit S8?
Generally, yes.
It's an email exchange between you and Ms. Hoey in June of 2017.
Yes.
And I'd like to draw your attention.
Exactly.
The last email is simply her saying to you, noted, thank you. I'd like you to go down to your email to her, which is 3/4 of the way down the page. It begins, hey, Sarah. Would you read the first sentence that you wrote to her?
Sure. So it says, once you have a vested permit, you are okay even when we sunset the development agreement.
That's all I asked you to read, Mr. Niven. So in June of 2017, you are telling Ms. Hoey that when the development agreement goes away, her vested permit doesn't go away, correct?
So in June of 2017, the administration and the staff believed that we were going to adopt vested provisions consistent with the moratorium, which would be a complete application.
Oh, so you are saying that when you wrote this, you believed that it all depended on what the city council did, correct?
Yes.
Okay. And did you say anything in here about it depending on what the city council did?
Nope.
Didn't you assure my client's representatives that there would be no gaps, and once they vested, they would be able to continue to develop their property?
I believe that what we told your client was what we believed to be true at the time, and that changed as the council weighed in on the procedure and ultimately decided a different outcome.
So it's your testimony then that you always believed that the city council could take away vested rights. Is that a fair statement?
I would characterize it to say, I believe the city council got to choose the outcome for vested rights.
Okay, I want to pull up the exhibit C6 that your attorney asked you about. I want to, while we're looking for our copy of it, I'd like you to...
I have a copy for you, if you want to use mine.
Thank you. We found it, thank you. So I want to direct your attention, Mr. Niven, to the second page of this document that you testified about already.
Okay.
And I want to direct your attention to the third paragraph under the heading Evaluation.
Okay.
And can you read that to us?
It is the administration's support, alternative 2, as it is consistent with the vested rights doctrine and the decision of West Main versus Bellevue, since the administration requires a land use permit to be issued prior to the submittal of a building permit, a complete land use permit has been viewed by the administration and city attorney as part of the building permit process.
Okay, so can you explain what you are, I assume you blessed this memo if you weren't the author of it. Can you explain what the West Main versus Bellevue case is all about and why it's relevant to vesting?
So my understanding, I'm not a lawyer, my understanding of West Main is that a city cannot add steps to a process to basically make it harder for a property owner or an applicant to vest. So in other words, if we say before you submit a vestable permit, like a building permit, you have to go through a land use permit, and before a land use permit, you have to go through a pre-app, and before pre-app, you have to go through a stage 0 meeting. Because all those are sequenced and mandatory, that stage 0 meeting is actually part of the building permit, and therefore would be a vestable point of a permit process.
And that is, in fact, the city of Issaquah's process, is it not?
It's not.
Doesn't the city require, before an applicant can apply for a building permit, that the applicant obtain a land use decision?
The code allows for a consolidated permit.
My question, Mr. Niven, is does not the city require an applicant before they can even apply for a building permit to have a land use approval?
I don't think that's consistent with city code, no.
It's not what I asked, Mr. Niven. I asked what your staff require. You require an applicant to get a land use approval before you will allow them to apply for a building permit, correct?
I don't believe my staff is inconsistent with city code, and city code says that you can apply for a building permit consistent with your land use permit.
Okay. Could we mark this, please, as Exhibit S9?
Thank you.
I don't think we can project this on the screen, but this is a copy of, it's a printout from the city's webpage. I printed it out. I printed it out in March. I confirmed last week that it's still on the city's webpage. It sets out, well, why don't you explain what this is, Mr. Niven?
Well, this says commercial multifamily building permit submittal requirements.
Okay. And let's turn to page 2. Application checklist. See that?
I do.
Pre-submittal requirements. See that?
Yes.
What's the first requirement for pre-submittal of an application for a building permit?
It says land use permit notice of decision has been issued.
So your own city checklist requires a notice of a decision issued on a land use permit before you will accept a building permit application, correct?
That's what this document says.
This
Yes.
is your document, Mr. Niven, correct?
This is the document that is on the city's webpage.
Okay. So the city has a West Main problem, doesn't it? As stated in your memo from November of 2017.
Mr. Chairman, I'm going to respectfully disagree with or object to that. That clearly calls for a legal conclusion apart from being argumentative.
I agree.
Okay. Let's go back to your exhibit C6. The paragraph that you previously read that refers to West Main versus Bellevue. You see that?
Yes.
And the second sentence is entirely consistent with the exhibit we just offered, is it not? Since the administration requires a land use permit to be issued prior to the submittal of a building permit?
So that paragraph is in error. It's consistent with other parts of the city, but not the development agreement, which was optional.
Mr. Niven, you just testified about this document, and now you're saying it's an error?
Yes.
What is the error?
I believe that paragraph is in error.
How is it in error?
The city does not require the land use permit be issued prior to the submittal of a building permit.
The application requires a notice of decision on the land use permit, correct? I mean, the pre-submittal requirements that we just went over? Let me rephrase it, Mr. Niven. This paragraph is entirely consistent with the application materials available on the city's website, correct?
This paragraph would be consistent with the submittal checklist that we just looked at.
Okay. And in November of 2017, when this memo was written, that was the city's process, correct?
Was the city's process?
To require a land use notice of decision before you would let anyone apply for a building permit.
I've answered that I do not believe that to be consistent with city code. Is our staff conveying that to applicants? I don't know. I don't sit in on pre-application meetings. What I can tell you is what's in city code and my expectation that we follow city code.
Are you saying you don't know what your staff does, Mr. Niven?
I'm saying I'm not.
I would object to
That's
that,
not an
Mr. Chairman.
appropriate comment, please.
Well, Mr. Niven, you're saying you don't know whether what your staff tells the public or applicants is consistent with the city code or your own documents?
I am not.
Mr. Chairman,
in
that's the same question phrased slightly differently. I would respectfully reiterate my objection to that.
Please. I agree.
So, turning to the questions that Mr. Lell asked you about why it took so long for you to send these applications to this commission, you testified last time that you made the decision that the Development Commission was the decision maker in March, correct?
Yes.
Okay, and then you talked about some staffing challenges to explain the delay?
It said there were a number of reasons, one of which was staffing.
Did any of the staff assigned to my client's applications change?
No, but they were new to the city.
You said one of the reasons was that it was our fault because we didn't respond to your request for revisions. Is that correct?
That is one of the reasons, yes.
Okay, so when did you ask for us to revise our application, and how long did it take us to respond?
I'm going to have to ask you to defer that question to Ms. Sloman because I was not involved directly in the permit review.
Mr. Niven, you testified. I'm asking you, what are the facts that were the basis for your testimony to this commission that we were responsible for delay?
I indicated that that was my understanding, which it is, based on a conversation I've had with my staff. Do I have those dates? I do not have those dates.
So you have no factual basis for your assertion that the delay is our fault, correct?
I have the word of my staff.
So let's turn to the Polygon application. You offered a new exhibit, which was, I'm sorry, Exhibit C8, that explains why they're vested, and IHIFC is not, correct?
That was my intent with Exhibit C8, was to explain the question that was asked at the last commission meeting.
Okay, well, at the last commission meeting, you agreed that the Affordable Housing Development Agreement said nothing about vested rights, correct?
I did not. I agreed that the development agreement, which was different, did not.
No, that's not correct, Mr. Niven. And
I would respectfully object here, too. He's basically testifying for the witness. He can ask questions, but I don't think that line is appropriate.
Okay.
I have a transcript from the last hearing, and perhaps we should mark it as an exhibit.
I have it.
Yeah. You 9, I didn't ever get it. Not, yes, not. I know, but that's, yeah.
Okay, I'd like you to turn to page 39, please, of the transcript.
Okay.
Okay? And we were talking about the development agreement with Polygon for affordable housing. Can we agree on that?
Yes.
Okay. And you were saying that you needed, well, why don't I ask to read the question and you read the answer that you gave last time, Mr. Niven. So why don't we start with line 14 on page 39.
Okay.
So if the question is why did Polygon get to proceed under the provisions of the Issaquah Highlands Development Agreement and not the replacement regulations, or excuse me, that's your answer. I apologize. You're basically saying you need more time, correct?
That's what I was asking for at the last meeting, yes.
Right. And then your next answer concludes, here we're on the last line of the page, saying you will definitely have it by the next meeting?
That's the commitment I made, yes.
Okay. And is Exhibit C8 that answer?
It attempts to answer that question, yes.
Okay. So now let me read my question at the top of page 40. Question. Okay, well, why don't we assume for the moment that this is the only other development agreement, and if I'm wrong, I apologize, but isn't it fair to say there's nothing in this particular development agreement that addresses vested right? And what's your answer?
I would agree with that.
Okay. So you did testify last time that the Polygon Affordable Housing Development Agreement says nothing about vested rights, correct?
No, you keep adding the word affordable. The development agreement and the affordable agreement are two separate legal documents.
Okay, so which document are you talking about?
This one that I included with Section 5 termination is the affordable housing agreement with the city.
Where is that agreement? I'm genuinely bewildered, Mr. Niven. I'm only aware of one agreement, development agreement with Polygon. So if there are two, how do I find the other one?
I can provide you a copy. I don't have it with me.
Yeah, perhaps you could have your attorney provide me a copy before the next hearing.
Sure.
I'd be happy to work with staff on that and submit that as a city exhibit.
Thank you.
Can you write that down?
Give me just a moment, please. I think we're done. Thank you, that's all.
All right. Mr. Lowe, you asked for equal time or some time, so.
Thank you, Mr. Chairman. I'll be very brief. I just have a very few follow-up questions for
Thank
Mr.
you.
Niven.
And this will conclude this portion. Thank you, Mr. Niven, for your patience.
Thank you, Mr. Chair.
Mr. Niven, I'd like to revisit your answers to Mr. Schneider's questions regarding the commercial and multifamily building permit submittal requirements that were apparently retrieved from the city's website and marked as Appellant's Exhibit S9, and particularly what was referred to throughout your testimony and Mr. Schneider's questionings as the West Main issue.
Yes, sir.
Okay, could you please turn to section 1801050C of the Issaquah Municipal Code?
Yes.
Could you please read that code section aloud?
1801050 in the Issaquah Municipal Code is a section called Authority and Vested Rights. Subsection C is titled Vested Rights. It says, nothing in this chapter shall be interpreted to require an applicant to obtain approval of any other permit or approval from the city prior to applying for a building permit. All city determinations regarding vesting shall be made only by the Development Services Director in consultation with the city attorney.
Mr. Niven, is that provision, as you understand it, inconsistent with the application checklist item regarding a land use permit notice of decision being issued that Mr. Schneider referenced?
Yes.
In your opinion, does the city's codified regulation on this point supersede or otherwise trump a document pulled off the city's website entitled Submittal Requirements?
Absolutely.
In your experience and observation as the city's Development Services Director, which of those two approaches does the city follow? The code approach that you just quoted, or the provision of the submittal requirements that Mr. Schneider referred to?
So I'm going to, again, take the fifth and say I do not follow permit applicants from pre-app to permit. I can't testify as to what is being told to permit applicants in pre-application meetings.
Thank you. Are you aware of any other code section in the Issaquah Municipal Code that addresses that West Main issue in the same or similar manner as IMC 1801050 subsection C?
I'm going to say yes. I believe there is a section in the land use code that deals with consolidated permits. I can't tell you what code section that is. I don't know it that well. I apologize.
Okay. With respect to the memorandum that Mr. Schneider referred to in his second cross-examination, I believe it was City Exhibit C6, and the reference in that document to the a particular vesting approach being consistent with West Main?
Yes, sir.
Okay. To clarify, was that reference of being consistent with West Main intended to mean the staff's preferred vesting alternative as it was recommended to the city in the fall of 2017?
Yes.
Is there anything in that document that would suggest or conclude that the other proposed vesting alternatives under consideration were inconsistent with West Main?
No.
Thank you. Are you aware of any other communications to the City Council that carried that conclusion?
No.
Thank you. Did anyone at IHIFC ever claim any confusion to you or anyone in your department because of any information they found on the website of the city?
No.
Thank you. I have no further questions.
Okay.
And I would just like to object if I'm not going to be allowed to ask any more questions. I understand we're trying your patience, but this has introduced new topics that were not part of the testimony. A new code section reference to communications with my client. I think if we are going to have redirect, there should be some opportunity for cross.
And with respect, Mr. Chairman, this is precisely why these sort of back and forths don't go on forever. I would object to that request simply because two reasons. A, that's not how the process that we agreed to was going to be formatted. And second, the questioning and answering that I just engaged in with Mr. Niven was very clearly within the scope of Mr. Schneider's second cross-examination.
I think we've reached our limit on examination and cross-examination. I appreciate the patience of Mr. Niven. I think we need to move ahead.
Thank you, Mr. Chairman. The city's second witness is Ms. Lucy Sloman. And be happy to take a break if that's the commission's preference.
That might be a good idea. We agreed in our agenda that we were going to go till 10 o'clock tonight, so it probably would be valuable for everybody to take a 5-minute break. We'll start back at 8 o'clock. Okay, we're back in session. Mr. Lowell, I think it's up to you.
Thank you, Mr. Chairman. The city's next witness is Lucy Sloman. Ms. Sloman, I don't believe that you've been sworn, so I would invite the court reporter to administer the oath.
Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Do.
Thank you. Could you please state your full name for the record?
Lucy Carter Sloman.
And what is your official title and position for the city of Issaquah?
I'm Land Development Manager. I'm in charge of planning and engineering current permitting.
How long have you held that position?
Since early 2012?
And how long have you worked for the city?
Since early 2012, but I was a consultant for many years before that.
Okay. And how long have you worked in the field of land use planning?
More than 30.
Okay. What does your role at the city involve in relation to land use project permit applications?
I am primarily responsible for content and to some extent timing. I also sometimes work on overseeing writing of code to make sure it's suitable for implementation by the planners and engineers.
Thank you. Do you have personal knowledge of the subject matter of tonight's hearing, specifically the 1996 Issaquah Highlands Development Agreement, the city's promulgation and adoption of the replacement regulations for the Issaquah Highlands area that were enacted under Ordinance Number 2830, the development of the Issaquah Highlands area under the 1996 Development Agreement, and the submittal, processing, and evaluation of IHIFC's various land use applications?
I do.
Thank you. Ms. Sloman, I'd like to ask you a series of questions first regarding the submittal of IHIFC's preliminary plat application. And to that end, I'd like to introduce City Exhibit C-9.
Thank you.
Ms. Sloman, could you please identify this document?
It appears to be the application materials that were submitted for the preliminary plat of IHIFC's properties.
Thank you. And could I call your attention to the bottom left corner of the first page of that document and the date reference there?
That it was submitted on August 1st, 2017.
Thank you. Was the preliminary plat application deemed complete by the city?
Yes.
Was the preliminary plat application submitted before the build-out period under the development agreement had expired?
Yes.
What is the current status of the preliminary plat application?
It's out for corrections.
And what does that term mean, out for corrections?
That in staff's review, there were either corrections or additional information that was necessary, and those items were identified and sent back to the applicant.
Thank you. Did IHIFC's preliminary plat application disclose an intended zoning or land use for the property?
Yes, we had asked, and they had shown land uses for each block, identifying how much of their total entitlement was retail, commercial, and a couple of residential units.
Did the preliminary plat application depict building footprints or otherwise indicate a specific physical development scheme for the underlying property beyond dividing the property into separate lots?
Not when it was submitted.
Thank you. Did IHIFC subsequently amend or supplement its original preliminary plat application?
Yes.
In what way?
On December 15th, we received, so we use an electronic permit review, which means that things come through mybuildingpermit.com, and we received a submittal. When we get those, I don't really do this a lot, but as I understand it, applicants pick what they are doing, and in this case, it was selected, the purpose was a change in original project.
Thank you. I'm going to be, actually, this is C10, pardon me. Introducing into evidence exhibit number C10. Can you please identify this document?
This is the first page of the original plat submittal.
Okay.
No date on it. First page, I assume it's the original version.
Okay. Could I draw your attention, please, Ms. Sloman, to the note number 7 in the middle of the page,
Yes?
beginning with final plat and building permits? Could you please read that to me?
The note that was submitted, note 7 that was submitted, said final plat and building permits are vested to the development standards under the Issaquah Highlands Development Agreement. The allowable development shown on this plat has been fully mitigated for the Issaquah Highlands Development Agreement.
Could you please turn to the planning comment by Jean L. immediately to the right of that? And what does that say?
This statement needs to be revised or deleted as some of the information is not true and/or unclear. For example, it is not possible to vest building permits that have not been submitted and issued. Additionally, the use of the term fully mitigated is not true if mitigation is intended to include road frontage and utility improvements.
Okay. And I believe that you had identified this map, this plat, as being part of the applicant's submittal in August. Is that correct, or was this submitted subsequent to that?
Well, I assumed that it was the original submittal. I am looking in the places that I would normally see a date, and I do not see one, and I have not, so I'm not able to confirm that.
Okay, thank you. Now I'd like to introduce City Exhibit C11.
We can write that on there. Go ahead, just pass them out.
Could you please identify this document?
So these are two examples related to the IHIFC plat of what mybuildingpermit.com generates as kind of like a cover application form. On one side, where you see the mybuildingpermit.com logo, you can see that on December 15th, the plat was revised, and the reason for this submittal was change in the original project. On the other side is another example of a submittal from August 28th, 2017, and the reason for this submittal was response to reviewer comments.
Okay. With respect to the applicant's submittal referenced on the first side of that page, the December 15th, 2017 submittal. Could you please describe that? What was being submitted?
So this particular submittal was one that increased the amount of information that was shown in the plat to include things such as building footprints that were not included in the original submittal.
Okay. Did this December 15th, 2017 submittal occur after the build-out period expired under the development agreement?
Yes.
Okay. Did the city request the applicant to submit this additional submittal?
No.
Did the applicant submit it on its own volition?
I would assume so. I'm not the permit lead, but that is my understanding. I think that is partly indicated by the reason for this submittal.
Okay. Were you in the hearing room to listen to Mr. Niven's cross-examination testimony by Mr. Schneider at the October 24th hearing?
Yes?
Do you recall the discussion concerning the notice of application that was issued for the applicant's preliminary plat and referenced, I believe, at what is now referred to as Exhibit S1?
Yes.
Okay. And do you recall the discussion of that notice of application as including building footprints?
Yes.
Do you understand, or could you explain why that document would have contained building footprints if the original submittal in August did not contain them?
I would assume that it was just taking the more recent plan, not as an indication of agreeing with or supporting that as part of the plat.
Thank you. I'd now like to introduce City Exhibit C12.
We can write it. Mark the official. Very good, smart. That's great. Thank you.
Thank you.
Can you please identify this document?
It is, I assume, part of the submittal components that came in August. It's dated July 15th, but I assume that it came in August with the preliminary plat, and it's labeled as Plat Project Narrative.
Okay, so just to be clear, this document, as far as you're aware, was included within the application packet for the applicant's preliminary plat in or about August 2017.
I mean, it's typical, it is a typical submittal requirement to have a narrative.
Thank you. Could I please turn your attention to the bottom of page 2 of this document, the very last sentence beginning with the words, "the plat."
The plat does not propose construction of any structures. Rather, the allocation of allowable development included in the plat will be implemented by future specific development proposals.
And could you please continue reading through the next sentence?
The applicant anticipates that the future development on the lots created by this plat could include buildings reaching up to 8 stories in height, or 8 stories height, some of which may include ground level retail with parking provided either on grade, below grade, or in a parking structure.
Thank you. I'd like to now introduce City Exhibit C13. you please identify this document?
The complete application determination.
Okay. And the city staff name listed in the signature block is Jean Lynn.
Yes.
Could you please identify Ms. Lynn?
She's a senior planner with the Development Services Department.
Okay. What was the purpose of this document?
I'm not sure. I assume it was at the request of the applicant to provide a written determination of complete application. The reason I'm uncertain is we don't typically issue these because the development agreement specifies that we have 10 days to either notify the applicant that the application is not complete, or if we do nothing in after 10 days, it is automatically determined to be complete. So we do not typically issue these.
Thank you, but you did in this case.
Right.
Okay, thank you. I'd like to introduce exhibit number C14. Could you please identify this document, Ms. Sloman?
Well, the first page looks like the same kind of cover sheet that comes in from mybuildingpermit.com that was shown with C11, and the second page looks to be the revised site plan that came in December. The date on it is December 14th, 2017.
Thank you. So to clarify, if I understood your testimony, this mybuildingpermit.com reference and the attachment relates to the attempted submittal by the applicant in December of 2017, not the applicant's original plat application of August 2017. Is that correct?
These are materials that were submitted in December, not with the original submittal, and are part of their, as they identified, change in original project.
Thank you. I'd like to identify and introduce into evidence City Exhibit C15.
Thank you.
Could you please identify this document?
It is a sheet from the preliminary plat. It's dated 12, I can't quite read it, I think it's 15/2017.
Was this part of the applicant's attempted supplemental submittal in December of 2017?
I would assume so based on the date, but as I said, I'm not the reviewer, so I'm not 100% confident that this sheet was included.
Thank
But
you.
based on the date, I would assume so.
Are you familiar with the replacement regulations that were adopted under ordinance number 2830 and are now codified at chapter 1819B IMC?
Yes.
Did you participate in the drafting or preparation of those regulations?
I did.
What was the zoning or land use category for the IHIFC property under the 1996 development agreement?
Urban Village.
What is the current land use or zoning category for the IHIFC property under the replacement regulations?
Urban Village Com REIT, which means commercial retail. And then there is a more detailed sheet that provides the specific amount of unbuilt zoning cap that the property has, as well as any other important elements needed for future development.
Okay, thank you. And going back to the preliminary plat application materials that were identified as Exhibit C9 and the project narrative that the applicant submitted in conjunction with them, are you aware of anything that was disclosed or otherwise depicted in those materials that would not be allowed under the replacement regulations?
No.
So if I understand your response, in other words, is it your opinion that IHIFC could fully develop its property in accordance with the development plans that it, I would note, Mr. Chairman, that it's not a leading question if there is a possibility for differing answers.
Okay.
It leads to a yes or no response to a detailed statement. It's a leading question.
I can't hear you. They can't hear you on the...
Sorry, it's a detailed assertion, I believe, about a legal interpretation. The question is, how do you interpret it, or what does this mean? It's not a lengthy statement by an attorney that you ask a witness to agree to.
Can you reframe your question,
Yes, sir,
please?
Mr. Chairman. In your opinion, Ms. Sloman, could IHIFC fully develop its property in accordance with the development plans it showed on its original plat application under the replacement regulations codified at Chapter 1819B IMC?
The plat contained roads, parcels, and a certain amount of land use, as well as utilities, and those could have been built under the replacement regulation. Those would have been allowed under the replacement.
And to reiterate, I believe your earlier testimony, or to clarify that, is there anything about the applicant's proposed use as disclosed in the application materials that would be prohibited under the development regulations or the replacement regulations?
Replacement regulations and the land uses and amount of land use that were shown on the plat are consistent.
Thank you. Could you please describe generally the applicant's ASDP and SDP applications that are at issue in this proceeding?
So there are 3 land use permits that we are looking at as part of this process. One was for a retail center. It's located along 9th Avenue between High Street and just south of Ellis Drive. It's located on 5 lots. The uses that were identified were entertainment, retail, daily goods and services, and restaurants. There were several buildings that comprised about 111,000 square feet in single-story buildings, and the potential for an additional 7,900 square feet in a second stories on some of the buildings, as well as 485 surface parking lots. Medical office building is located near the intersection of Discovery Drive and 8th Avenue on a site that's about 2.8 acres. The uses were medical office with ground floor retail. The building contained about 92,400 square feet. It was 4 stories and had 394 parking stalls, mostly in a parking deck. The third land use permit was for a storage building located near Discovery Drive and 6th Avenue. The lot would have to be adjusted to accommodate the proposed building and associated elements. The building had about 105,000 square feet in 4 stories, 3 of which were above ground, with 34 surface parking stalls.
Thank you. Do these applications relate to the same property as IHIFC's preliminary plat application?
Yes.
When were the ASDP and SDP applications filed with the city?
The retail and medical office building were submitted in November, and the storage building was submitted in February. November 2017, February 2018.
Were each of those submittal dates after the build-out period under the 1996 development agreement had expired?
Yes.
Did IHIFC submit a building permit application concurrently with any of its ASDP or SDP applications?
No.
Did IHIFC attempt to submit a building permit application?
Not that I'm aware of.
As compared to other permit applications that are typically processed by your office, how complex were the circumstances under which IHIFC's ASDP and SDP applications submitted?
Well, they were pretty complex. We were trying to end the development agreements, prepare the replacement regulations. There were questions around mitigations and how that would be handled. And so there was a lot of uncertainty associated with those permits.
Did you ever inform IHIFC that its ASDP or SDP applications were permanently vested such that they would not ultimately be subject to the replacement regulations?
No.
Are you aware of any other city staff member that informed IHIFC that its ASDP or SDB applications were permanently vested in such a manner?
Not that I'm aware of.
Mr. Chairman, members of the commission, I have to apologize. I'm going to be submitting into evidence right now several documents that are entitled sufficiency letters or determinations, and unfortunately there are many of them. I'm not going to have Ms. Sloman testify at length regarding each of them, but they do need to be technically labeled as exhibits.
Okay.
So Ms. Sloman, I'm going to introduce into evidence several documents, beginning with a December 1, 2017 letter from the city to Tia Heim. I'm going to label that C16.
Okay.
And for expediency's sake, if by your leave, Mr. Chairman, I'll simply just list the other letters by designation instead of introducing them by name, if that's...
Good idea.
Thank you. Thank you, and I apologize for the delay, Commissioners. What will be handed out shortly are a series of letters from the city's Development Services Department to the applicant, specifically the applicant representatives, primarily Tia Heim, David Holmes, and Scott Howman. These letters are dated December 1st, 2017, December 27th, 2017, December 27th, 2017. There are two different letters at the same date. January 26, 2017, although that's a misprint, and I'll have Ms. Sloman testify to that. It's actually intended to be 2018. February 9th, 2018, February 23rd, 2018, and March 9th, 2018. And in the interest of time, if I could proceed with just some general questioning by Ms. Sloman to kind of lay the foundation for these materials.
Please do.
Ms. Sloman, what's a sufficiency determination in city planning parlance?
See the exhibits if they're being talked
Yes.
about? I asked if we could see the exhibits.
I'm going as fast as I can, but since they're not going to be referred to by date, I wanted to make sure that they're all clear what they are. So I'm labeling them.
Happy to pause.
Are these all being offered as C16?
No,
No, they're all
they're being
separate.
offered sequentially by date.
So would there be benefit to a 5-minute break to get some paperwork in order? Would that help?
That would
Sure,
be-
thank you very much.
Let's take a 5-minute break. No, don't be sorry.
Apologies.
Let's take a 5-minute break. We're on the air. So
Thank you,
please
Commissioners.
continue.
I appreciate your patience with that. What you've just been handed are city exhibits C16 through C26. These are a series of sufficiency letters, and in lieu of identifying each document and discussing each document individually, I'd like to have Ms. Sloman briefly discuss and describe what a sufficiency determination letter is.
Only half through 19. You can continue, Mr. Lau, but I just would like the rest of them.
Could you describe what a sufficiency determination letter is, Ms. Sloman?
When an applicant submits a permit, we take the submittal requirements and compare the materials that have been submitted to the submittal requirements to ensure that we've received everything that we have identified as being necessary to review the permit.
Okay.
Doesn't mean that we agree with it, it just means that we have received sufficient information to begin our review.
And the 10 documents that have been provided into evidence this evening, designated C16 through C26, do you generally recognize those as sufficiency determinations for IHIFC's property projects?
Yes.
Could you please generally summarize what some of the issues and purported deficiencies were that led to these letters?
I would say they fell into two broad camps. In some instances, there were items that were identified that were not provided, and we were asking for those to be incorporated into the drawing set. The other, at a high level, the other category was that because the preliminary plat had not been completed, some of the items that were identified, such as property lines, legal descriptions, and rights-of-way, didn't in fact exist yet. These were sort of concepts or proposals, but not they weren't final.
Did the concerns or deficiencies identified in these letters prevent the city from determining that the applicant's ASDP or SDP applications were complete?
Right. Without those materials, we said we identified that we needed those materials to be provided to reach completeness.
Great. Thank you.
Or to determine them to be sufficient.
Thank you. I'd like to draw your attention to the March 15th, 2018 letter agreement that is appended to the staff report as attachment 5.
Yes?
Are you familiar with that document?
Yes.
As it relates to the completeness determination for the applicant's ASDP and SDP applications, what was the purpose of this letter agreement?
The purpose was to reach an agreement on how to proceed, given that the plat wasn't complete and there were items that would not be completed until the platting process was done. And there was a desire by the applicant to have a determination of completeness prior to the platting being complete.
So was the effect of this agreement as related to completeness for IHIFC's ASDP and SDP applications that as of the date of the letter, March 15th, 2018, that those applications would be deemed complete?
Yes.
Okay.
Although the letter is dated the 15th, I believe the final signature was on the 18th.
Okay, thank you. And when was the replacement regulations ordinance number 2830, passed by the City Council?
The 19th.
So this agreement became effective one day before the replacement regulations were adopted?
Yes.
Thank you. Would you please describe the historical staffing and workload levels of the city's Development Services Department?
The Development Services Department was formed early to mid-2012. It was at a time when the city and region was coming out of the recession. It was a very busy time with a lot of work going on, especially in the urban villages. When the Development Services Department was formed, It was a combination of many different departments and divisions in the city. There were approximately 4.5 FTE of planners, current planners, in that department. By the time we got to 2016, we had increased up to approximately 5.5 FTE. But at the end of 2016, and similarly as a result of coming out of the recession, we began to see a very high staff turnover. That turnover continued and kind of accelerated into 2017, in which all of the current planning staff left the city and were replaced. There were periods of time at which we only had one current planner that had 1 year of experience. When we were fully staffed, which was not until I think mid-July, we had only one senior planner rather than the 2 or 3 that we had had prior to that. And all of our planning staff, as I said, were from outside Issaquah. 2 of them were from outside the state. Most of the staff had just a few years of experience.
So did this affect staff's ability to devote time and attention to permit applications that were submitted by applicants under the 1996 development agreement?
Well, we devoted attention. We just didn't make as much progress, or it wasn't as speedy as we would have liked, because there was so much training going on to get them up to speed.
Did the city previously have a special arrangement with an outside party to partially fund staffing levels within the city's development services center?
It wasn't so much in development services. The major development review team was a group created specifically to review projects in the urban villages. That was funded and paid for through 3-party agreements with the master developer, Port Blakely Communities. Towards the end of 2013, they desired to end their active engagement with Issaquah Highlands in particular, and to not administer the 3-party contracts, which required them, all of us, to bill every single hour individually, and then them to redistribute all the time out to the various builders. And so they demanded that the city go to a more traditional model in which it was based on permit fees and some amount of general fund.
So what is the current status of that outside funding arrangement?
There is no outside funding.
Thank you. Was the funding support previously provided under that arrangement ultimately replaced by other funding sources in the city?
Well, the city had to look at permit fees and what return they expected as part, or how much they expected the department to be self-supporting.
Did you deliberately delay any aspect of the administrative processing and review of IHIFC's applications in any way?
No.
Are you aware of any other such deliberate delay by other staff members within the Development Services Department?
No.
Going to introduce into evidence City Exhibit C27. Okay. Can you please describe this document?
At the time that On the day that the council was considering adopting the replacement regs for both Issaquah Highlands and Tallis, I received a request from the deputy city administrator or by certain council people to understand if the, what I call straight time, is applied to the permits that were submitted by IHIFC, how would those have played out? This, I believe, Mr. Snyder has shown the chart that I developed on that day. That was a very quick construct on my part. With some of the questions that have come up around that, I went back and revisited that to a little more thoughtfully look at the time, and this was my spreadsheet to try and understand that.
So to clarify, you created this document recently in preparation for this hearing? Is that correct? Okay, thank you. Could you please describe the time tracking analysis here as it relates to IHIFC's SDP and ASDP applications for purposes of processing and review and ultimate completion?
Sure. There have been assertions that if we had just followed the timetables in the development agreement, that things would have been approved prior to the adoption of the replacement regulations. So there's, what this chart lays out is starting with the submittal of the preliminary plat on August 1st, 2017, and using the time that the MDRT and Development Services had developed with Port Blakely Communities as being our standard preliminary plat timing. How many days would that, how would that fall on the calendar? And that would have been November 26th. Then assuming that the next day, the site work permit for building the infrastructure was submitted, and that had a standard of 48 days. That would have brought us to January 14th. Then assuming the next day, the final plat was submitted, and that had a standard number of days of 61. That would have resulted in March 17th, 2018. That is coincidentally the day before the completeness determination of the 3 land use permits that exhibit number 5 from the staff report, March 18th, 2018, and then looking at the days identified by the development agreement for site development permits and administrative site development permits, those would have resulted in July and May. There are 2 notes, I think, that are worth pointing out. The assigned times in the development agreement, the Appendix L processing agreement, has a footnote that says that these times are assume adequate staffing levels as determined by the city.
I'm sorry, I was going to introduce that as an exhibit.
Oh, I'm sorry.
Hold on 1 second.
Sure.
I'd like to introduce City Exhibit C28, please.
Thanks.
Thank you. I didn't mean to cut you off.
No, thank you.
Could you please identify this document?
Sure. C28, Exhibit C28 is a page from the Issaquah Highlands Development Agreement, Appendix L, which is the processing appendix, and it is a very complicated chart of how all the processes and steps and timing associated with permits, land use permits. And at the top, you see it says Appendix L, Part 1, City Processing of Land Use Permits Chart. And then there's an asterisk, and if you go down to the very bottom left-hand corner, you can see that the asterisk shows that it assumes adequate staffing levels as determined by the city. That's one piece I would point out, that although these times are in the development agreement and we take our implementation of the development agreement seriously, there is a recognition that things happen, and I think 2017 was a classic example where we were down to one planner at one point with very little experience. The second piece that I would point out on C27 is that the times that are identified in both C27 and on C28 that's why I call it straight time. If we ask for additional information, if we ask for corrections, if the date falls on a weekend, any of those things might result in the time being increased. For instance, the preliminary plat date of November 26, 2017 is a Sunday. So there are things like that that might result in it being pushed out further.
Thank you. Did the city have a tentative or estimated date by which it assumed the replacement regulations would be adopted?
In the fall, I was just looking at that today, in the fall of 2016, we identified at a council workshop October 2017. By the time we began to bring the drafts forward, we were aiming for December of 2017.
But the ultimate adoption date, if I'm not mistaken, was March 19th of 2018. Is that correct? Okay, thank you. Given the dates upon which IHIFC's ASDP and SDP applications were submitted to the city, based on your personal knowledge and experience, even if the city's staffing had been at historical levels during that period, would the city have been able to complete the processing of those land use applications and issue final decisions on them before the replacement regulations were adopted?
I don't really see how. For instance, the preliminary plat has been out for corrections for a period of time. The reason is that the applicant has had questions about the comments that we've made, and we've been responding to those. And as we go back and forth, that's taken some time to understand and work through how we're going to proceed.
Thank you. And one further question concerning the city's staffing levels, which I believe you testified were significantly lower than the norm during 2017 because of turnover. Is that correct?
Yes.
What was the city's planning workload like during that period? What other projects did the city have currently pending?
We had quite a few big projects. We had a series of site development permits, some other plats, the Costco site development permit, and which was quite large. So some like IHIFC, other applicants were hoping to get their permits through before the end of the build-out period of the development agreement.
Thank you. And I believe you testified that you were involved in the drafting and promulgation and presentation of the replacement regulations.
Yes.
Could you clarify the nature and extent of your involvement?
My main role was related to orchestrating the writing and mapping, so the content piece.
And approximately how many meetings of the full city council were at least partially devoted to the topic of the replacement regulations?
There were 2 full council meetings and 2 work sessions.
And approximately how many meetings of the Land and Shore Committee?
At least 8.
And approximately how many meetings of the Planning Policy Commission?
At least 4.
And how many formal public hearings were held on the proposed replacement regulations?
2.
Were there any informal public outreach meetings or workshops?
Yes, there were 2 at Issaquah Highlands and some other ones at Tallis.
Did you communicate with IHIFC regarding the replacement regulations during the legislative process?
Yes. When we were ready to bring the draft forward to the Urban Village Development Commission and Planning Policy Commission, I began to collect email addresses for the homeowners associations of Issaquah Highlands and Tallis, some of the large property owners or unbuilt properties, and other what I called interested parties. And we began that in July before the first meeting in August, and continued that until both sets of replacement regulations were adopted.
And when you say both sets of replacement regulations, what are you referring to?
Initially, we brought forward 1 set of replacement regulations for Tallis, Issaquah Highlands, the Highlands Transit-Oriented Development, which is where the Y and Z home are, as well as most of the WashDOT TDR development agreement area. And but in December of 2017, the council decided that they thought it was more appropriate to pull those apart. So Tallis became 1 set of replacement regulations. Issaquah Highlands, Highlands TOD, and the WashDOT TDR properties were another set of replacement regulations.
Did IHIFC participate directly in the legislative process for the replacement regulations?
Yes, as far as I can see from my records, the first presentations that we made were in August 2016, and then a work session in September 2016 to council. And I see that there was a letter from Tia Heim to the council in response to that, and I think there were, in my records, I found at least a dozen letters from IHIFC about various components of the, commenting on various components of the replacement regulations.
Did IHIFC representatives attend the meetings of the city's council, Planning Policy Commission, Land and Shore Committee?
Yes, they often attended and testified and submitted letters.
Okay. Are you familiar with the provision of the replacement regulations governing vested rights codified at IMC 1819B 280?
Mostly, yes.
Okay. Can you describe the process the city utilized to promulgate and ultimately adopt that provision?
So I assume those are the processing, that's the processing section?
Not the processing section. This is specifically
the vested rights. Sorry. Yes. So the vested section took a somewhat different route than some of the other sections. When we, during the summer and early fall, we were meeting with, jointly with the Urban Village Development Commission and the Planning Policy Commission. The vesting section was not part of those drafts. We considered that to be a policy decision on the council's part. And during the time that they were reviewing other sections of the replacement regulations, we were discussing internally and with the city attorney how best to proceed. Then in October, the draft that went to council included the first language. Following that, we had a series of memos, redrafts, presentations, other processes trying to answer council and community questions and determine how we were going to proceed.
Great, thank you. I'm going to introduce City Exhibit C29. please identify this document?
This is one of the interested party emails that I sent. This one is dated December 14th, 2017.
Okay. And what was the purpose of this message?
The purpose was to update the email list regarding the fact that the replacement regulations had been divided into two separate agenda bills, that this would be coming to the council on December 18th, that it would be on the consent agenda, which means that there would not be discussion, and that we were then going out to the community in January and then returning to council or council committees after that.
Thank you. I'm going to introduce City Exhibit C30. This, I believe, is a replica of a document that Mr. Niven previously talked about, but I believe part of the discussion was deferred to you. Could you please identify this?
So this was a memo that Mr. Niven and I wrote to further the conversation that the council was having around vesting and minimum FAR, floor area ratio.
Okay. Could you describe the contents of this document as it relates to vesting, both sides?
So I didn't write the front of it.
Okay.
He punted to me. I'm punting back to him.
Could you discuss the second half, then,
All right.
the back page?
This was, Keith and I were working to try and explain, there were interest on the council to understand which properties were not developed, what their status was, whether they would be vested by various techniques, and what we were trying to identify was that certain things would be, as the third column states, vested by the state, meaning by our understanding, there was something in state regulations that would have vested those permits, whether that was not part of the policy decision that the council could make. But in the fourth column, vested by the proposed language, what that meant was that based on the proposed language at that time, those permits that were in purple would be vested.
So is it your testimony that that column with the designation proposed vesting language meant that the corresponding permits applications would only be deemed vested by the city if the staff recommended vesting language for the replacement regulations was ultimately adopted?
Right, that the language that was currently under review, if that language was adopted, then these would be vested. If that language changed, then they may or may not be vested.
Okay, thank you. I'd like to introduce City Exhibit C31. Could you please identify this document?
This is excerpts from the PowerPoint presentation I used at the November 21st Council Land and Shore Committee. It's the cover sheet. The first page is the cover sheet. The second page is kind of like an agenda. And you can see that the fourth topic that was going to be discussed was vesting, and then the last 2 pages of this exhibit are the 2 slides relating to vesting that staff used.
Okay. Did you communicate directly with IHIFC's representatives concerning the promulgation and ultimate adoption of the vesting clause in the replacement regulations?
I personally did not know.
Okay. Approximately how many meetings or telephone communications have you had with IHIFC or its representatives since IHIFC acquired its Issaquah Highlands property?
At least 15 or 20 related to the various permits, the possibility of a development agreement, the plat, et cetera.
And approximately how many written communications, either letters or emails or memoranda, have you had with IHIFC or its representatives since they acquired the property?
Since in searching my email, I see that Ms. Tia Heim sent me at least 60 emails, that I sent her at least 70 emails, included the interested party emails, and I found at least 12 letters in my records.
Approximately how many personnel hours of city staff time would you estimate have been devoted toward IHIFC's pending land use applications from 2017 to present?
Hundreds of hours.
I'm sorry, could you say that again?
Hundreds of hours.
Thank you.
I'm estimating based on the kinds of meetings, the review necessary, the attendance at the meetings. There were typically 2, 3, 4 people who would attend a meeting depending on the topic. There were sometimes follow-up written responses or comments that were prepared.
Okay. In your dealings with IHIFC, did you act consistently, honestly, and in good faith?
I did.
Did you ever deliberately discriminate against IHIFC or otherwise deliberately target IHIFC for negative, disparate treatment?
Absolutely not.
Did you ever inform IHIFC that its ASDP or SDP applications were permanently vested such that they would not be subject to the replacement regulations?
No.
Are you aware of any other city staff member that informed IHIFC that its ASDP or SDP applications were permanently vested in that manner?
No.
Thank you. My final exhibit will be labeled
32.
C32. Could you please identify this document, Ms. Sloman?
Excuse me, we need to hang on a moment. I think I've lost all my notes.
And apologies, and we would not object to a recess.
Yeah.
Why don't we take 5 minutes and
Let's
see
take
if I
5
can
minutes.
recover?
Yeah. Second session.
Thank you. Ms. Lohman, could you please identify Exhibit C32?
Sorry, I tried to get organized. C32 is an interested party email that was sent on February 2nd, 2018.
And in relation to what?
It was in relation to it was announcing an upcoming Council Land and Shore Committee meeting on February 8th and identifying some of the key changes and items of note that were in the materials that we were distributing in preparation for that meeting.
At the bottom of the page, under the several items to note, could you please read the first item?
Number 1, the vesting language has been changed to match state law rather than the previous broader vesting language. As this is an administration decision, the mayor has offered to discuss this change with concerned parties.
Thank you. Ms. Sloman, the staff report for this proceeding concludes that IHIFC's ASDP and SDP applications are non-compliant with the replacement regulations codified at Chapter 1819B IMC, and it recommends that the Development Commission deny those applications. Could you please briefly summarize the basis of this conclusion and recommendation as to the permit applications in question?
We had in May 2018 sent the applicant a letter asking them to update their applications to be compliant with the replacement regulations. They had at the end of May declined to do so. So an in-depth review was not performed, but because there were certain sort of big picture pieces that were coming from the replacement regulations that would not have been compliant. Generally, those would have been a certain minimum amount of structured parking, a minimum floor area ratio, and a certain size plaza that was required for non-residential buildings.
Thank you. I have no further questions.
Okay. Mr. Schneider, are you ready? Or I guess I would ask what kind of timeline you're on. How long do you think your cross-examination will take? Would this be an appropriate time to break? Or are you ready to forge ahead and then have us break? I don't know how long you intend to.
Well, it certainly won't be done by 10.
Okay.
If people are tired, we can resume on Wednesday night when we're coming back. It's up to you. I'm certainly prepared to go ahead, but we can also, if we break, I suppose I'll be more efficient, but either way is fine with me.
No objection to breaking, Mr. Chairman.
Is this a good time to break, or should we go for it?
I'm good for efficiency, so if Mr. Schneider can be more efficient on cross when we come back on Wednesday next week, because we're scheduled again for next week,
Okay.
that would probably work. I'm not quite sure what progress we're going to make in 30 minutes.
Okay. Let's resume next Wednesday. If everybody, it sounds like people are agreeable to that, we appreciate it.
And just to be clear, we'll be back in this room again on Wednesday. Is that correct?
That's my understanding.
As far as I know.
6:30 to 10 again.
Okay. Oh, I was just going to ask whether it would be possible to at least start thinking about, if not actually choose a future date, because we're not going to get done on Wednesday.
Okay. Yeah.
So I know that at a minimum, the commission has a standing meeting the first and third Wednesdays of the month. So I would ask that we not meet on the 2nd of January, but that we look at January 16th and then potentially another date later in January with the same sort of proximity. I believe it's January 16th would be the typical Development Commission meeting night, and then we will look for something either that week or the next week.
I'd be happy to discuss this with staff. From our perspective, there's certainly no reason that we could not schedule another special meeting as well in a more condensed time frame, assuming staff's availability and capacity for that.
So let's assume the 16th, and we'll also work on identifying hopefully a second night in January. We'll need to work with the commissioners, staff, and the applicant to identify that second date.
Now, realizing that there is a sense of urgency, we're trying to expedite this in any way we can. So I think in general, the commission is willing to be as flexible as we possibly can, and so.
So we'll look for a second date similar to what we've done November 29th and December 5th. We'll look for a second date around the time of January 16th to meet. We just need to ensure that we'll have the members and the applicant and staff are available.
Right.
And is there any possibility to meet on December 19, which is a Wednesday? I realize it's a week before the Christmas week, but that is a Wednesday.
What?
I'm available. I'm available.
We had held that for another meeting that night.
It's a standing commission meeting night, so do we have?
Right, but there was another commission who we, so let us take a look. We will, as I said, try and come up with dates before we meet again on the 5th.
Okay, is that agreeable?
Yes, thank you.
Okay, so let's consider ourselves adjourned.
Thank you.
Okay, thank you.